Hi, welcome to Community Women's Voices. This show is a collaboration between NARAL Pro-Choice Washington and the Seattle chapter of NOW. Today's show is called Bush versus Choice, the truth about the federal abortion ban, and you're going to hear about a case that went before the United States Supreme Court on November 8th of 2006. And we're going to talk a little bit about what a decision in this case might mean in the lives of women living here in the United States. I have a couple of guests in the studio with me to help shed some light on this topic. We've got Joan Schrammick and Sarah Ainsworth. Joan, do you want to tell us briefly about your organization?
I'm with Cedar River Clinics. We're the Feminist Women's Health Center, and we're located in Renton, Tacoma, and Yakima. We provide first and second trimester abortion, birth control, well women's health care, and advocacy to preserve access to choice.
And what's your role with that organization?
I'm the Development and Communications Director.
Thank you. And Sarah, how about you?
Absolutely. My name is Sarah Ainsworth, and I am an attorney at the Northwest Women's Law Center. The Northwest Women's Law Center is a regional nonprofit women's rights organization. We do litigation, we advocate for legislation, and we provide self-help legal materials to women to educate them about their legal rights. We work on all areas of women's rights. My particular specialty is violence against women and reproductive rights.
All right. Thank you very much, and thank you both for joining me today. So, as I said in the introduction, we're going to be talking about the federal abortion ban. But honestly, when I speak about it in those terms, you're probably saying, what? I've never heard of this before. Joan, talk to me about why our viewers may have never heard of the federal abortion ban before.
Well, the anti-choice movement calls it the partial birth abortion ban. And partial birth is not a medical term, and it has nothing to do with birth. Partial birth abortion is an inflammatory term that was invented 10 or 11 years ago by the anti-choice movement. When they tried to pass an initiative here in Washington State in 1998, they called it infanticide. The purpose for this inflammatory, made-up term is really to mobilize the anti-choice people and to cast doubt into the hearts of pro-choice people. It was invented at a time when the anti-abortion movement and the lobbyists were trying to take attention away from the fact that the anti-choice movement had supported people murdering doctors.
Okay. So partial birth abortion is not a medical term.
That's right. There is a procedure called the DNX, or intact DNX, and it's when the doctor removes the fetus intact. And it is a newer abortion technique that has been designed specifically to ensure the best safety for the woman's body, to offer the least risk of a tear to the uterus or to the cervix. And when a fetus has a fetal anomaly, the intact DNX allows the doctors to remove the fetus and then they can do a careful examination of the tiny baby's body in order to try to figure out what's gone wrong. But more importantly, doctors who care very deeply about their patients, about the women they are serving, designed this technique to ensure that they cause the least amount of risk to the woman's body and can do the best thing possible to preserve her future ability to have children.
Well, I think it's very interesting what you're saying about partial birth abortion not being a medical term, because if you've been following the press on this at all, television, newspapers, partial birth abortion is the term that's used over and over and over again, in spite of the fact that what you're saying, that this is in fact a made-up term and is not any medical term and not the proper term for, I suppose, whatever it is they're trying to get at. So just a little lesson in media literacy and media justice, I guess. So Sarah, can you talk to us just a bit about the legal background? Why is this happening? Why is it happening now? Sure. What's happened before this that got us to this point?
Sure. I'm gonna try to be brief, but I think it's important to understand the background a little bit. Okay. So, help me out if I start getting too jargony.
All right.
So in 2000, the U.S. Supreme Court decided the case called Stenberg versus Carhart, and it was a case addressing a very similar, almost identical ban on abortion in the state of Nebraska. So it's a state law that prohibited doctors from performing the term partial birth abortion, so very broadly, vaguely defined procedure, and it contained no exception for when the procedure would be necessary to preserve a woman's health. And for those two reasons, the United States Supreme Court struck down Nebraska's law as unconstitutional because an exception in any abortion regulation that protects a woman's health is required. And likewise, under Roe versus Wade and the cases that came after it. Likewise, the term partial birth abortion, as Joan has explained, is so vague and doesn't really define any kind of medical procedure that doctors wouldn't know what was prohibited. And so they would be afraid to provide abortion procedures because they wouldn't know what they could do or not do.
The term partial birth abortion is used in the laws that have been tried to be passed also?
Yes.
It's not just what the media is picking up on?
That's correct.
Okay, so legislators are using this term as well, even though it's made up.
That's right.
Okay.
So the impact of that is that a doctor could be prosecuted for doing something that is routine and isn't at all the procedure that Joan just described. They wouldn't know necessarily. So in fact, less doctors would be willing to provide abortion services, and a woman's right to get an abortion would be undermined. And that's why the Supreme Court struck that down. But it's important to note that that was a 5-4 decision. So there were 5 justices finding this law unconstitutional, 4 that would have upheld it. The 5th vote was Justice Sandra Day O'Connor, who's no longer on the United States Supreme Court. So now, just 6 years later, the United States Supreme Court is addressing the federal law, which is identical to the law passed in Nebraska. And I think there are a couple of reasons why we're here. First, Congress knew, because Justice O'Connor gave them a roadmap in the last decision, how to write a constitutional law. As long as they preserve a woman's health, as long as they clearly define what procedure they're prohibiting, that law could be upheld by the Supreme Court, according to Justice O'Connor. Congress knew that. They enacted an unconstitutional ban anyway, and they tried to get around that by having findings on their record that this procedure, whatever it is, would never, ever be needed to save a woman's health. So, of course, advocates for women filed lawsuits throughout the country against this law once it was passed and signed, and all of the courts around the country have enjoined the law, so it's not in force, and have found it unconstitutional because it doesn't contain the safety exception, etc. And in those cases, the lawyers have brought all kinds of doctors and other healthcare providers to testify that, in fact, yes, this procedure, whatever it is in fact sometimes necessary to preserve a woman's health. And because that directly conflicts with what Congress said, the courts have said, well, Congress is wrong, this is unconstitutional. So the U.S. Supreme Court took that case just 6 years after issuing an almost identical decision and an almost identical law.
And I'm not a scholar on the Supreme Court, but that seems kind of odd that just 6 years after they heard of almost identical case that they would be hearing it again. Is that common for the Supreme Court?
It's not at all common, and in fact, it's very striking. A perfect example is the very well-known decision in Lawrence versus Texas. This was the case upholding an individual's right to privacy and striking down Texas's law that criminalized sexual relationships between people of the same sex. So that just came out a few years ago, and less than 20 years prior, the United States Supreme Court had upheld as constitutional a similar law in another state. So just within a couple of decades, they're reversing themselves, and there was enormous attention paid to that because it was so unusual. And here, we're looking at only 6 years. It's extremely unusual.
And so what's that about?
I think, and I think most legal commentators would agree, that it's because of the makeup of the court. Since Justice Sandra Day O'Connor retired, and she was replaced, Justice Rehnquist retired, and he's been replaced, and so we have a new Supreme Court.
Well, let's be clear. Who made these nominations, and who are the people who make the new Supreme Court?